Hello everybody, and welcome to my video blog, which is part of my website, uslegalwriting.com. You can get to the blog by just typing uslegalwriting.com and adding /blog. Now personally, I've never cared for the use of Latin in legal writing. I know it has its defenders, but to my ear, terms like res ipsa loquitur and inter alia, they just look and sound pretentious. And I think they interrupt the flow of a legal argument, too. Who really wants to shift languages in the middle of a thought? And while I'm on the subject of conventions that have outlived their usefulness, if they ever had any, I also don't favor using the said in front of every noun that crops up. And I try not to write subsequent to when the word after will do just as well. These practices just complicate things more than necessary. For years now, some legal writing scholars, including maybe the best known, Brian Garner, have been beating the drum for using plain English in our legal discourse. I've got a link to his Law Pros homepage in the text version of this post. Apparently, these voices in favor of scrubbing our legal writing of some of this ancient gunk has had a good effect upon judges. Dr. Kathy Kellerman, a communications consultant, recently published online a slideshow revealing the results of a survey of hundreds of judges. The person who conducted the survey was Mr. Flammer, and he published his results in an article titled Persuading Judges, an empirical analysis of writing style, persuasion, and the use of plain English. The article appears in the Journal of the Legal Writing Institute, and there's a link to Kathy Kellerman's slideshow in the text version of this post. The study asked the judges whether they found plain English or traditional legal writing. The study asked the judges whether they found plain English or traditional legal writing more persuasive in the memoranda and the briefs submitted to them. Now I have to assume that the phrase traditional legal writing is a euphemism for writing that's loaded up with lots of Latin, liberally sprinkled with heretofores and aforesaids and all the rest of it. Anyway, the results were telling. More than 2/3 of the appellate judges surveyed found plain English more persuasive. 63% of the trial judges surveyed agreed. And among women judges, the numbers were even more dramatic. 83% liked plain English. Now, this is all good news, it seems to me, and apparently we're moving in the right direction. But that doesn't mean that as advocates we can now just jettison all of our latinisms and the other traditional verbal baggage. Our job still has always been to persuade the judge assigned to our case today, right now. And that person might not agree with the surveyed majority. So what to do? Easy answer. If you can, read some of your judge's recent writings. If he or she shows an affinity for the hoary old style, then by all means dump in the said, heretofore, inter alia, whatever, any other burdensome lingo that comes to mind. But if you don't have any clear evidence that your judge favors pretension, leave it alone. Go with plain English. According to Flammer's study, the odds now are with you. And of course, before I leave this topic, I should consider that you might not be among the choir to whom I'm preaching. Maybe you like the occasional Latinism yourself. In that case, I leave you with these thoughts, with due apologies in advance to any ancient Romans who might be watching this video. A communae observantia non est residendum. Translation, there should be no departure from common usage. By common usage, I mean ordinary English. Or maybe this. Acta exteriora indicant interiora secreta. Translation, outward acts indicate the thoughts hidden within. How does that relate? Try this. If you persist in the traditional style, you might be telling the reader a little bit more about yourself than you really want to.